Welcome back to our podcast, everyone. Today, we're diving into a fascinating topic that touches on the intersection of law, religion, and the informal labor sector in Uganda.
Absolutely. We're discussing Ronald Serwanga's chapter, Doctrine of Undue Hardship and Religious Accommodation in Uganda's Informal Labor Sector. It's a deep dive into how the law balances employer rights and employee religious practices.
So, to kick things off, let's talk about the central question raised in this chapter. How does the law respond when an employee's religious practices conflict with their employer's needs?
Right. And this is especially tricky in Uganda's informal economy, where many workers lack formal contracts or protections. It really raises the stakes for those trying to practice their faith at work.
Exactly. Religion is such an integral part of personal identity and conscience. But in practice, many informal workers face discrimination or unfair treatment when their religious practices come into play.
That's where Serwanga's chapter makes its mark. It discusses how Uganda's constitutional framework can actually protect religious accommodation while recognizing the operational needs of employers.
And it's fascinating to see how the Constitution upholds rights like equality and freedom of religion. Articles 21, 29, and 40 are key players here.
Yes, and Article 43 is particularly interesting because it allows limitations on rights, but only if they are justifiable. This creates a framework for potentially resolving conflicts between religious accommodation and business needs.
Absolutely. And the chapter also highlights the legal tools available, like the Employment Act, which aims to prevent discrimination based on religion. How do these laws play a role in practice?
Great question. It's crucial for employers to understand that treating workers unfairly because of their beliefs is not just bad practice. It's illegal. But then the chapter introduces the doctrine of undue hardship, which complicates things.
Right. The doctrine asks when an employer can refuse a request for religious accommodation due to substantial difficulty. How do we find the right balance here?
It's all about finding solutions that work for both parties. Can shifts be rotated? Can prayer times be scheduled during less busy hours? These are all questions that can help bridge the gap.
And let's not forget the judicial decisions highlighted in the chapter. They show that while religious freedom is protected, it's not absolute. Any restrictions need to be justified.
Exactly. The decisions from cases like Demond Sharon v. Makerere University illustrate the delicate balance that needs to be maintained.
For researchers, this chapter provides valuable insights into workplace discrimination and the responsibilities of employers. It also connects broader themes like dignity and access to justice.
And it's especially relevant for scholars focusing on the Global South, as it develops the doctrine of undue hardship within Uganda's unique context, rather than just replicating foreign models.
So, to wrap up, this chapter is not just an academic exercise. It sheds light on how the law can protect religious practices while also respecting the practical needs of employers.
Absolutely. For anyone interested in labor law, human rights, or the relationship between law and religion, this chapter is a must-read. Thanks for tuning in, and we hope this discussion has sparked your interest.
Join us next time as we continue to explore how law shapes our everyday lives. Until then, stay curious and engaged.